Hello, everyone. Welcome to week 5. What week is it? Is it week 5? It's week 5 of PPA 551. This week we're going to be talking about equal employment opportunity law and protections in the workplace for different individuals, for workers, and for employers as well. This is a really important topic for the niche group of you that are interested in working anywhere ever. So if you fall into that group, I think that you're going to get a lot out of this lecture today. We're going to talk about the different historical trends that have impacted employment law as we've seen it, and hopefully, at the very least, you'll be able to take something out of this for yourself to understand your own rights in the workforce, if not prepare you for a career in equal employment opportunity law and regulation. I want to start with this example here. This is a more recent policy change that isn't reflected in our lecture today, but I want to call this out in case you're not familiar with how with the concept of arbitration in the workplace. So Biden signed what they called the Me Too bill, which made it easier for women to sue their workplaces or former workplaces over harassment allegations. The traditional way that contracts are structured, especially in right-to-work states, especially in states that have maybe a less of a union culture as well, is that if you have issues, oftentimes you would go to HR, and HR would resolve it through a process called arbitration. Arbitration is essentially an out-of-court legal proceeding. When you enter an arbitration, you and whomever the other party is are entering into an agreement that this format, whether it's through a mediator, whether it's through your HR department, whether it's through a collective bargaining agreement, whatever it may be, whatever process it is, you're agreeing that you will be legally bound by that outcome, even though it's not a legal outcome. This is a process that has historically been used as a protective mechanism for employers, for organizations, for government agencies, because taking something to court is costly for both parties. It's time consuming, and especially if you're a public agency, it's bad press. And so, particularly as it came to sexual harassment, traditionally, the way that had been handled is through an arbitration. A person would make a complaint to the appropriate department, whether it's their human resources department or what have you, and there would be set up some sort of mediation and arbitration. Then the harassment lawsuit or the harassment allegations would be resolved to whatever extent within the arbitration setting, and the outcome was there. Arbitration prevented people from taking further legal action because, according to their contracts, they were required to participate in an arbitration. This is what this bill specifically is attempting to address, is the forced arbitration. And so what this allows employees to do is it allows them to void contract provisions that mandate third-party arbitration. So that essentially require you to go through a third-party arbitrator and not take something to court if you are harassed in the workplace. And so this law makes it easier for people to opt out of that part of their contract. This arbitration system is just one of many examples of a workplace culture that has ebbed and flowed, has risen and fallen with the current of equal employment law. A lot of times, at least in the private sector, equal employment law is seen as a barrier to good business. It is a government regulation. It is something that is preventing a business from being able to do what they need to. In public HR and nonprofit HR, we are bound by those same equal employment opportunity laws, but we're also bound by merit-based employment laws and other things that offer protections, and we have a different interest in mind. We're not necessarily operating businesses all the time, and so the protections for our employees can be treated a little bit differently. Unfortunately, That's not how public HR departments have often been run, and that's what we're going to talk about today. So let's get to it. For our lecture today, we're going to start with talking about just in general what EEO laws are and what its implications are for our strategic human resource management programs, right? So far in this class, we've understood the process of design thinking, the process of thinking through, what are our needs, what are the different needs for our positions, and how are we going to create a plan that's going to get us to the place we need to be in the future. However, equal employment law often puts barriers in the way of just doing whatever we want with our human resource management. And so, public employees get extra constitutional protections that are not available to nonprofit or private employees. And it's important to understand those differences as well as the general equal employment laws that we have to be able to follow. So, we're going to cover mainly this slice, I'm bad with colors, I'm going to go with orange slice, today we're going to talk about things like Title VII, we're going to talk about GINA, we're going to talk about ADA. But there are a ton of different buckets of employment law that if this is something that interests you, A, you can go to law school and study exclusively employment law, but B, it's important to understand these different dynamics, especially if you're planning on entering an HR role. Things like interview laws. That's a really good example. A salary history ban. That's something that Colorado recently passed that makes it illegal for us to ask when we're hiring a new candidate what they previously made at their old job. The idea is that it prevents the indiscriminate use or manipulation of a hiring range based on what someone previously worked. The policy previously made it work. The policy implication being that if we just hire people based off of what the position is comped at, what it is supposed to be paid at, then we're preventing any sort of arbitrary decision making at that point. But this is a whole lot of different stuff, and in one of the videos posted on our Canvas page for this week, you'll talk more about labor laws, minimum wage, classification, talk about exempt versus non-exempt employees. Very, very critical video for you to watch, so please take a look. Federal employment laws, when you're looking at these different laws, in general, we're going to talk about 10 as the big buckets. There's a couple up front that we really need to hone in on for you to understand, but employment law is its own bucket of work that I don't even care to try to understand the complexities of that sort of stuff. The Family Medical Leave Act, FMLA, is one of the most important laws that we need to understand. It provides job-protected leave for family and medical reasons, right? So if you are, I used to work in leave management, so I know the FMLA provisions by heart. So if you've worked for an employer, the same employer for the last 12 months, and you have worked at least 1,250 hours in that past year, you're eligible for 12 weeks of FMLA leave. FMLA leave is not paid leave, but for certain situations, whether you're sick with a serious health condition or an immediate family member of which you're the primary caretaker is sick, you get that leave that you can take, and they have to preserve your job or an equivalent job for you upon your return. Now, it's very milquetoast, but it's really important, especially for organizations that may not have robust leave policies, and especially for lower level, line level employees that need to take advantage of that. We'll talk about the Equal Pay Act. This prohibits sex-based wage discrimination. This is really important. If you remember, this came up big right around 2010 or so. The Lilly Ledbetter Act was also passed to help provide additional protections for wage-based discrimination. Then we have OSHA, right? Occupational Safety and Health Act. This is a safe work environment, right? It created an entire compliance agency that investigates workplace injuries and accidents, right? The Pregnancy Discrimination Act, another important one to protect pregnant women in the workplace. The National Labor Relations Act. This protects employees' right to join a union and collectively bargain, engage in the grievance process, right? Participate in strikes for the sake of that mutual aid and protection. This is really important. The history of employment law in America was built on the backs of collective bargaining and unions, and so the NLRA is a really important law to understand. GINA, we'll talk about that a little bit later, but it protects employees from discrimination based off of your genetic information. That's got some crazy context to it. ADA, this is one, Americans with Disabilities Act, prevents discrimination for individuals with disabilities. Then we have ADEA, which is the age discrimination in employment, which protects people based off of their age. The Fair Labor Standards Act. FLSA is what set the minimum wage. That was minimum wage didn't exist before FLSA. And then Title VII of the Civil Rights Act, which is all of the bucket of protected classes that you cannot discriminate against in the workplace or in hiring. Race, religion, color, skin, sex, sexual orientation, parental status, nationality, age, disability, political affiliation, military service. All of those protections fall under Title VII, but as you can see, Civil Rights Act needed a little bit of bolstering with these other laws, right? So let's start way back when the workforce really started becoming a thing in the mid to late 1800s with the Civil Rights Act of 1866. This was a statute based off of the 13th Amendment, which was the end to slavery, which prohibited the racial discrimination in the making and enforcing of employment contracts, including hiring and promotion. It applied to nonprofit and private employers, unions, and employment agencies. This was really the first step that the federal government took to protect workers in the workplace, right? Then you had the Follow-up Act in 1871, based off of the 14th Amendment, which prohibited the deprivation of equal employment rights under state laws. So, as the ebb and flow of civil rights law has always happened, progress is made in certain states, progress is restricted in other states, and you end up with differentiations in who has what rights depending on where you live. And so the federal government often has to step in and help level the playing field in terms of setting that bottom barrier. So in 1871, the bottom barrier was basic deprivation of equal employment rights. And this was the one that applied to state and local governments. This is where it really hit that public sector employee before public sector employees were as popular as they are today. EEO is something that has been hotly contested in the workplace, and it's really important for people to be aware of their rights. In a lot of modern workplaces, especially in the public sector, you're going to see posters like this all around talking about, you know, learning your rights as an employee. The way that our laws have been structured is that it puts the burden of knowing your rights and understanding your rights on employees. Now, as public sector regulators, HR departments have to know and defend those rights as well. However, it's not their primary function. If a violation of your employment rights happens, it's incumbent upon you to report it, right? It's not necessarily, you know, HR isn't watching over every conversation that happens that may violate something like the ADEA, right? And so posters like this exist in almost every public workplace. Break rooms are often littered with posters like these about knowing your workplace rights. Obviously, nothing happened between 1871 and 1964, and so here we are in 1964 with the Civil Rights Act. Title VII of the Civil Rights Act is one of the most important laws for our context within HR ever passed, right? This prohibited discrimination based off race, color, religion, sex, pregnancy, sexual orientation, gender identity. As of 2020, that was a recent change to it, or national origin. This applies to all employers with 15 or more employees, except these other exceptions that don't super apply to us right now, other than the places of employment connected to an Indian reservation. Because they are sovereign nations, this does not apply to them. But this 15 or more employees is a really important barrier that a lot of these laws have in them that make it so that frankly, almost every government organization is going to qualify under this. But the idea behind this is that this is a trade-off that's made in the policymaking process. The idea is that we don't want to put too many restrictions on small businesses. Now, the subtext of that is, well, we want small businesses to be able to discriminate, but there's other things that go into it. But this 15 or more employees is often the barrier that you see in a lot of these laws. In 1972, this expanded to state and local governments and schools. This was a really important expansion because employment law had been separated for a really long time, and still to a certain extent is separated between public sector and private sector work. In 1972, it took Title VII and those protections and applied it to state and local governments, essentially overriding any state laws that may have said otherwise. This also created the most important regulatory agency in this situation, the EEOC, the Equal Employment Opportunity Commission. EEOC, similar to OSHA, is required to investigate complaints and resolve disputes through conciliation. This is not something where they're coming in and they're shutting businesses down because of this. They go in and essentially offer to be mediators that can reconcile issues within the workplace. And then there was the bona fide occupational qualification exception. I'm going to go ahead and skip that for right now. It's not important for our context, but if you're interested, you're welcome to read more about that. But Title VII, really, really important. If there was a test, I would say this would be on it, but there's not. So please, please take care to understand Title VII of the Civil Rights Act. Religious discrimination. This is a really important one. What we're going to go through in this lecture is we're going to essentially take all those different sections that are protected under the Title VII, and we're going to say, well, here's how they're not protected, and here's what we've done to protect them, right? So religious discrimination is one of the hottest button issues in employment law, because under Title VII, employers are obligated to accommodate their employees or prospective employees' religious practices. You can think about this in terms of certain sets of Islam that have prayers every so often during the day that you have to allow to accommodate. This comes up with Judaism in the workplace with different holidays that they may need off depending on the set of Judaism they practice, right? Nonprofits governed by religious institutions as well are exempt from equal employment law. It's exempt from Title VII. So nonprofits run by churches, nonprofits run by religious institutions as defined by the tax code are exempt from these protections as well. Educational institutions, as we talked about in 1971, Title VII was expanded to educational institutions. However, educational institutions that are owned, supported, controlled, or managed by religious organizations or teach in specific religious contexts are exempt from law. That second is really important because you're looking at things like Catholic schools, right? You're looking at things that are specifically religious-based educational institutions. Faith-based initiatives is a way that equal employment opportunity advocates have tried to expand these initiatives to faith-based organizations, but because of the First Amendment, because of Title VII and the way that it's written, there's very little that we can do to require religious organizations to behave a certain way. But as you can see, really what's going to happen with Title VII is that we're going to take this really broad law and we're just going to start poking holes in it, right? We're going to start seeing where those gaps occur, right? Religious discrimination is a really difficult thing to understand because religion in and of itself it can be a pretty amorphous, ambiguous topic to discuss in the first place. Age discrimination, the ADEA. There's a different, the IDEA Act, and I taught education policy, and so IDEA and ADEA always mess with my head, so I have to say ADEA out loud. Anyway, ADEA, it prohibits discrimination in employment because of age, particularly as it relates to selection, retention, compensation, and other terms and conditions of employment, right? This protects workers over 40. Now, if you're a young person like me, you're probably thinking, well, where are the protections for people younger? Well, unfortunately, the ADEA was not written for that. Things like FLSA and other child labor laws help protect against that. That's completely different, right? Compulsory retirement in most cases is illegal because of this. This is something that, before even teaching this class, I wouldn't have even thought was a thing, but forcing employees to retire used to be a practice so that workforces can continue to cycle through employees. So in this case, in most cases, it's illegal. Here we're looking at 20 or more employees, unions of 25 people or more, employment agencies, federal, state, and local governments as well. There's an important caveat here related to our bona fide occupational qualifications. This relates to reasonable restrictions based off of a person's age, right? And so, for example, if you are working in a public works department and you're putting up power lines, right, there may be certain physical requirements of the work that older individuals may not be able to perform. That is an important thing to understand, that is not a violation of ADEA because it's not based off of age, it's based off your ability to perform the job. And there's some other topics here that may be of interest. Observe terms of a seniority system in an insurance plan. Employees are discharged for good cause. There's other exceptions for age discrimination that you can look at. But really the one that's important there is the difference between discrimination based off of age versus discrimination based off of ability to perform the job as it's written. Pregnancy discrimination. Now this is huge, and it still is a very imperfect law in a lot of ways. But the PDA of 1978 prohibited employment practices that discriminate on the basis of pregnancy, childbirth, or related medical conditions. A pregnant woman cannot be forced to take leave as long as she is able to work. This is kind of backwards from a lot of what we would talk about with leave policy, because it's employees trying to take leave and they can't. Well, pregnant women for a long time, if they were in the workforce at all, may have been forced to leave the workforce because they were pregnant. They may have lost their job because of that, and so you cannot be forced to take leave as long as you're able to perform your job duties, right? Pregnancy is treated as a disability under equal employment law. The term disability as it's connotated in popular understanding is not the same as the term disability as it's understood in equal employment law. And so pregnancy is treated as a disability. It's a disabling condition, especially when it refers to leave of absence policy. And then states are allowed to, this is a floor law, so this sets the floor for what you're able to do. States can pass laws granting additional benefits. Many states have passed laws that offer paid pregnancy leave, paid parental leave, family leave, which we'll talk about here in a second. Rehabilitation Act, 1973. This is based off of physical and mental disability. Now, this is really important to understand because this was not the same as the Americans with Disabilities Act. This provided a different sort of protection, which was job-based discrimination based off of a physical or mental disability. A person with a disability is defined as someone who has an impairment that affects major life activity, or a history of an impairment that does such, or is considered as having one. Mental health is still very misunderstood in most policy contexts, and so this was the first stab that the federal government took at protecting people with particularly mental disabilities as well. And then Executive Order 13548 was intended to increase federal employment of individuals with disabilities. When we talk about affirmative action, we'll talk a little bit about that sort of stuff as well. ADA, 1990, then amended in 2008. It provides that qualified individuals with disabilities may not be discriminated against based off of the disability in all aspects of their employment relationship, right? Whereas our Rehabilitation Act was a more general law. This really hammers home the parts of the workplace that cannot be the parts of a work agreement that cannot be based on the discrimination of people with disabilities, and it applies all the way through an application stage. You can't be discriminated, prevented from applying or interviewing for a job based off of a disability. You can't, and all the way through retirement. You can't be forced to retire, and you can't be prevented retirement benefits that based off of your based off of a disability or a disabling condition. This, once again, 15 or more employees. The amendment in 2008 was important because it redefined what disability meant so that more individuals could receive protection under the laws. Over time, courts had slowly chipped away and provided exceptions for what was considered a disability. So in 2008, the federal government went back in and redefined disability to provide further clarification for future court cases. The only requirement, because of the ADA, is that a person is able to perform the job functions. So a person who is bound to a wheelchair, if the job requires them to physically climb a ladder, going back to our public works example, that is not considered discrimination based off of a disability because they're not able to physically perform the acts of the job. But if all it requires is you to walk from one office to another, that would be discrimination if we then said, oh, well, you can't do that, because they can still, and just as effective as other people. And then the really important part here, especially from the employer side, is the reasonable accommodations portion of this. This is a huge, this is still changing and morphing depending on its context, but the reasonable accommodation is acts that we must take as employers to accommodate a person with a disability. A reasonable accommodation can be seen as anything from providing for a wheelchair ramp for a person bound to a wheelchair to get into the workplace, all the way through to allowing people who may be pregnant to come in a little bit later if that's what they need. These reasonable accommodations are defined by the employers and the employees in their relationship. It's not something that's written down in the statute. I'm going to skip this for the lecture, but please go back and watch this because equal employment opportunity law is always just a baseline. It always just sets the floor for what we have to do as employers to protect individuals and protect workers. This is an excellent TED Talk by Laura Bajardis, where she talks about why it's important to expand our understanding of equal employment law and why it actually benefits the company or the organization to go beyond what those base level laws say. Immigration Reform and Control Act. This one's peculiar, but I think if you know a little bit about general American history, particularly in the 80s and 90s, you'll kind of understand where this is coming from. So the Immigration Reform and Control Act was written because there was a trend of employers hiring undocumented immigrants, undocumented individuals over a qualified U.S. citizen to allow them to pay cheaper, to maybe not provide as many benefits, that sort of thing. But it also does the opposite, where it's illegal for employers to discriminate based off of an individual's citizenship as well. So it reinforces that the nationality component of Title VII, unless there's for some reason you're required to based on a separate law. And so this goes both directions, where it both protects employees based off of their immigration status, while at the same time prevents employers from arbitrarily hiring undocumented individuals as a way to save money and not have to hire a qualified U.S. citizen. So you can kind of see how it balances right on the tightrope of immigration politics, right? And then it also requires employees to verify identity and employment information for all employees completing an I-9 form and reviewing documents showing that identity. This is an important function of a lot of HR departments, especially if you're hiring someone who may have a different immigration status, and so you have to verify identity and employment eligibility for those classified employees filling out an I-9. The Civil Rights Act of 1991, this provided just additional remedies to deter and protect against unlawful discrimination and harassment. Like I said, it wasn't just disabilities. Really, the arc of employment law is that the law will pass, and then slowly courts will find holes, find gaps, chip away at what those protections are. And so essentially, in 1991, Congress went back, provided additional context, additional description, additional protections under the based off of what Title VII was intended to do, and restore the strength of those laws that Supreme Court decisions had started shooting down. This touches a bunch of different civil rights statutes and creates 3 new laws. And this created a system in which compensatory and punitive damages were made available to victims of private and nonprofit employers that may have fallen victim to this weakening of the laws. Public employees under this law are now only entitled to compensatory damages, not punitive damages. You can't hold a company. You can't hold an organization. You can't sue the organization for under a criminal law. So, now we're to FMLA. FMLA, like I said, up to 12 work weeks of unpaid job-protected leave. There's a bunch of different qualifying conditions that if you do work in HR, you have to understand, you have to be able to work off of. FMLA, from a personal perspective, like I said, I used to work, when COVID hit, I worked for an organization that provided leave of absence management. They were a leave management firm. And one of the things we did is that companies, including public organizations, the city of Fort Worth, different public institutions, we managed their leave policy for them because their HR either didn't have the skills or the staff available to manage it. And so FMLA provides job-protected unpaid leave. There's some important caveats, especially when we're looking at equity in the application of this law. So, yes, you get 12 work weeks, but the way that those work weeks are distributed out can sometimes be changed depending on the condition in which you're leaving under. For example, if 2 people work for the same organization and they have a child together, they can, in some circumstances, be required to share the 12 weeks. They don't get 12 weeks individually that they could stack on top of one another. But it does do a lot of good things where, birth and care for a child, and especially in situations where other sort of paid parental leaves aren't available. It provides those protections. To care for an adopted or foster child after placement, really important. To care for an employee's spouse, child, or parent. One of the things you have to do in leave management is verify that they have that not only is it a serious health condition, but that they are the primary caretaker. And so oftentimes people may be taking care of great-grandparents or grandparents, and if they can't be confirmed to be the primary caretaker, FMLA may not be available to them. And then personal serious health conditions. The definition of serious health condition is written down, but it's left pretty ambiguous and creates a lot of situations in which doctors are put in the position of having to determine whether or not someone has a serious health condition that would qualify them under FMLA. Then there's some military protections. We're going to talk about USERRA here in a second, but military protections for spouses, children, or parents of active duty members. So this was really important when the war on terror kicked up in the early 2000s, where people were suddenly called into they were military reservists who were suddenly called into action. And so what this allows you to do is allows the spouses, the children, and the parents of those people called up for duty to take protected time off during that time. It's an exigency leave, right? There's something urgent that came up, and so maybe you have to prep do all the preparation for someone leaving. Maybe you want to, make sure you pull the children out of school so you have extra time to spend with them before they go off. And so those different things as well. And military caregiver leave for individuals who are injured as part of their military service. That is also, caring for them is also a protected law or a protected class under FMLA as well. So FMLA, a lot of good things, but as you can see, just definitely still that baseline that it's built upon. Then there's some other armed forces protections. The big one is USERRA on the bottom, but let's talk about the Vietnam Veterans Adjustment Act. And so 1974, there was a massive trend of Vietnam veterans coming back with severe disabilities, with coming back to broken homes and situations in which veteran homelessness became a huge issue. Veteran employment had dropped significantly, and so under this, contractors are required to take an affirmative action, you hear that language, right, to employ and advance disabled veterans and qualified veterans of the Vietnam era. And then it employed to employers with government contracts of $25,000 or more. And so very limited in its scope, but has a very specific targeted outcome for Vietnam veterans, right? Then we have USERRA, the Uniformed Services Employment and Reemployment Rights Act, USERRA. This does what all of those words essentially tell you it does. If someone is a military reservist and they're called into action, you must be able to give them their civilian job back when they return from service. There are certain requirements that you have to meet, but for the most part, you are legally required to save a job for someone. You cannot backfill a position because they've left for a tour of duty. So armed forces protection is another really important bucket, particularly in Colorado, where we have a significant armed forces presence and veteran population. Let's talk about GINA. The Genetic Information Non-Discrimination Act, 2008. This prohibits employees from discriminating against employees or applicants on the basis of genetic information and bans the collection of genetic information except in limited circumstances. Sometimes you may be signing a contract to start a new job, and you may sign a GINA waiver because in certain situations you can opt out of that genetic collection. But this is essentially the idea behind this is that people were being discriminated against because they have a family condition that was something like a cancer that is predominant in females in the family, and so people were being discriminated against because they knew that at some point in the future that person may get cancer. And so GINA was a really important one. As you can see, this is one of those carved out nuances that in the 1960s and 1970s lawmakers wouldn't have even thought about. But not only is it discriminating based off of that information illegal, but it's also illegal to collect or ask for that information as well. That's not something you can do. GINA, another important one. Proving discrimination is an important component of this, right? We can talk about protections against discriminating practices, but what does that actually mean? Not everyone gets these protections, so you have to go and check to make sure that you are in a qualifying organization. You're either a government, a nonprofit that isn't a religious nonprofit, or you're an employer that employs more than 15, 20, you're a government contractor that has a $25,000 or more contract, these sort of things, right? When there is a case of alleged discrimination, it may violate one of the federal statutes we've talked about, one of the state statutes we could talk about. There's one or two theories, right? The first theory is the disparate treatment theory. When an employer treats an employee of a protected class, so of one of those classes under Title VII, differently from an unprotected employee class in a similar situation. And then there's the disparate impact, right? When an employer's policy or practice, which may be neutral on its face, has a negative impact on the employment opportunities of certain individuals. These two different theories are important because for a long time, disparate treatment was the only way that discrimination was understood. But disparate impact is just as important because oftentimes you'll often hear about race-blind or color-blind policies in the workplace that may actually have a disparate impact on on employees. And so these two different theories are what you would have to bring a claim for under one of these two theories to prove employment discrimination. What are some other remedies for discrimination? Well, affirmative action is probably the biggest one, and frankly, you could teach an entire class on affirmative action, and I'm sure places do. But in a situation where equal employment opportunity is a legal duty, affirmative action doesn't necessarily fall into that category. It can be voluntary or involuntary. So under these executive orders, the affirmative action applied to federal agencies, contractors, and subcontractors, including the facilities that the subcontractors run. And this requires those contractors and federal agencies to take affirmative action that not only protected against discriminating, but takes affirmative action to ensure that applicants and employees are not treated differently. Affirmative action looks like a lot of different things. For a while, it looked like racial quotas that you had to meet. You had to meet certain diversity quotas. The Supreme Court determined that quotas were illegal, but different institutions have made cases for why diversity is important, and so they take affirmative steps to get them towards a more diverse situation. Involuntary affirmative action, however, there are certain situations in which organizations have decided to implement voluntary affirmative action programs to redress previous discrimination and employment practices to make their workplace more representative, right? This is related to some of the DEI topics we're going to talk about next week, but voluntary affirmative actions are essentially suggestions that we make about improving diversity in the workforce. Involuntary affirmative action is more what we're talking about with the previous slide, which is forcing employers to take affirmative action steps. Right? It's permitted under the Civil Rights Act, which states that if a court finds that an employer has intentionally engaged in unlawful employment practices, it may order appropriate affirmative action. These are some terms that you may have heard, and it's important to know what they mean. So we have a conciliation agreement where an employer acknowledges the discrimination practices and agrees to comply with a change, right? A consent decree, this is probably the most popular one, an agreement between an employer and a compliance agency with approval and enforcement of the court. So oftentimes EEOC will enter into consent decrees with organizations to enforce affirmative action. And then there's just straight court orders, right? When a compliance agency takes an employer to court and the court just says, this is how you're gonna fix that. And so involuntary affirmative action can also be applied in certain particularly egregious situations in the workplace. And then there's additional constitutional rights that public sector employees and to some extent, they're protected by a broad umbrella of laws that prohibit a government activity or create an individual right. And so expressive rights, freedom of expression, equal protection of the law, privacy rights, due process rights, limits on political participation in the Hatch Act, these are different things that actually pull back on the rights of public sector's employees. You fall under these same buckets, but there are additional things that as public employees we may have to do. For example, limits on political participation in the Hatch Act, right? I, as a public employee, am not allowed to participate in certain political actions because it can be seen as bias, it can be seen as a politicization of a bureaucracy, right? And so constitutional rights may or may not be rolled back in certain public sector employee situations because of the different needs of public employees, right? So what I want you thinking about when we're talking about these EEOC law or these EEO laws is think about this in the modern context, right? We just had this situation with the terrible killing of Tyre Nichols. We continue to see, police brutality and police violence cause significant unrest, cause significant social movements, and the Black Lives Matter movement, the Black Lives Matter protests in 2020, the Me Too movement. Organizations have to respond to those in some way. And employment law is only one way in which employers and organizations respond. We're going to talk next week about DEI practices. And those are another way. But, how have your organizations reacted or responded to these different things? Have they just straight ignored them? A lot of organizations often do that. And then, how have organizational practices not changed? There are very simple steps that HR departments can take to respond and be proactive about their practices, such as blind resume review, where you don't see a person's name, where you can't subconsciously assign a race to someone, or race or ethnicity to someone based off of their application. And so doing things like that are simple, but a lot of organizations haven't taken them up. Why do you think that is? What are the barriers there? And then, we talked about the pandemic as well. The pandemic has exacerbated a lot of these issues. And so what situations has the pandemic created as well in your workplaces? Now, we'll talk briefly about some additional protections for employees. Workplace protections can also be extended that prohibit arbitrary or unfair treatment from employers through local, state, or federal statutes. Whistleblower protections is one thing. So if you are sharing information about potential corruption in your workplace, or potential illegal activities, there are additional protections that you can take. I have worked in a situation in which the colleagues have had to work with lawyers to ensure their whistleblower protections to share certain information about an organization, and so it's a tense situation, but it's another protection that's important that you understand you have. And then at-will employment, most employment in our context at least is at will, unless you're a contracted employee. Most employment is at will, and so you can terminate without notice, and you can also be terminated without notice as well under a lot of situations. And so there's additional protections that lie in there. Go ahead and start exploring some of these different protections that Colorado has specifically laid on. I really want you to pay attention to how Colorado has built upon some of these other laws that the federal government has passed that kind of set that baseline. But Colorado has, especially recently, has taken a lot of steps in expanding that. The 9 to 5 organization is a good example of workers' rights advocacy, protecting hourly employees. There's some agendas coming up. There are certain things that this group is advocating for in the current legislative session, particularly in Colorado, talking about the protections for service industry employees. So another group to look into. It's good to understand, particularly if you're interested in employment-based advocacy in the nonprofit world. And then we have the Colorado Family Medical Leave Act, the FAMLI Act, right? This isn't the FAMLI Act. This is the one passed by voters in 2020 that starts in 2023. This creates a situation that is intended to mirror FMLA, 12 weeks of partial pay and job security, and then 4 additional weeks of paid leave for serious health conditions, particularly as they relate to pregnancy or childbirth, and then covered if you earn at least $2,500 of wage during the period, right? You receive 90% of average weekly wage as a portion of their wages equal to or less than 50% of the state average weekly wage, right? These calculations are built into it, but the Colorado Family Medical Leave Act is a really important change to the way that Colorado employees are treated. My workplace recently had to make a decision that we chose to opt out of this act because we have our own system of protections that at least meet the minimum that this law has set, and so this is complemented with the Family Act that provided additional family medical leave protections as well. Colorado has a specific has a long history with migrant farm worker divisions or migrant farm worker protections. There's a lot. We have a long history, particularly on the Eastern Plains, Greeley, all the way down. that you have seasonal workers that will come in, that many of them are undocumented. They'll come in, they'll work, and they don't receive those same protections because they're undocumented or because they're migrants from another country. And so Colorado Legal Services has put together some information about protections specific to migrant farm workers in Colorado that if you're interested, you can take a look at as well. In this situation, Colorado passed the Agricultural Workers' Rights Law in 2021. This became effective last year, and it was the ability, it provided agricultural workers the ability to organize, join, and engage in labor unions. They also promised minimum wage because of this, the right to overtime pay, whether it's 12 hours a day or 40 hours a week, meal breaks, rest periods during the workday, access and transportation through their employer to necessary services, right? And so this is intended to meet a very specific need that Colorado has. There's also very, very minute details within this that are really important. Eliminating the use of short-handled hose that led to back injuries. So they were given shorter hose because they were likely cheaper, and because of the way that they were hunched over, they were getting long-term back injuries. And so you can also have the right to have visitors at the employer-provided housing. A lot of these farm laborers have on-site housing that they live on because it is a seasonal or temporary job. And then there's enhanced protections and safety precautions provided by the employer during public health emergencies, COVID-19 as the primary one, right? So this is an example of a very specific situation. So when we're talking about equal employment law, this is not something that you need to have memorized. This is not something that you need to know every detail, every line of the statutes. But what I really want you to take away from this is that one of the big roles and responsibilities of human resources, particularly in the public sector, is understanding and complying with equal employment opportunity law and affirmative action regulations. Employers have to be aware of this because not only is not being in compliance can cause legal issues, there might be fines, there might be investigations, but these laws protect your employees' rights. And so in our modern age, where I keep reiterating this trend of treating our employees as humans who happen to be employees rather than the opposite, we want to be able to understand what these protections are and what protections can be offered to individuals. Even on just a personal level as well, it's important for you to understand whether you or someone you may work with or know goes through a situation that may be covered under these. We don't do a great job, I would argue intentionally so, in educating people about their rights as employees. And so it's really important to understand this. And then in the broader scheme of HR management, right, it's important to implement strategies within our HR management to successfully manage a diverse workforce. The diversity is not going anywhere in our workforce anytime soon, and so it's important for us to understand those strategies and those situations. So I'm going to leave it there for today. I want to thank you all for taking some time to listen to me as the sun sets on another busy work day. So take care, stay warm, and we'll talk.